Good morning, everybody, and welcome to our class number 3 of our 2026 virtual HOA Condo Academy. I'm going to give people a little bit of time to join us here this morning. Happy St. Patrick's Day to start out to all of you. Today is Tuesday, March 17th, 2026, and we're going to be talking about tough conversations and turnaround tactics today. And kind of the basics of that are going to be dealing with difficult people, dysfunctional boards, and board recalls. So hi, everybody. I am just going to give everybody a few seconds for attendees to enter the Zoom today and get settled before we get started with our presentation today. Welcome to class number 3 of our 2026 virtual HOA and Condo Academy. We teach this class, these virtual classes for the Condo and HOA Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Just in a few introductions, my name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. Our firm currently represents over 1,000 planned communities and condominiums in the state of Arizona, and I also serve on my HOA board, actually 2 HOA boards, and I have done so for many years. So I think I bring an interesting perspective to these classes because I am an attorney that practices or specializes in this area of representing HOAs and condominiums. A second, I've served on my board, hard time, let me tell you, very hard time, for 14 years. And I've also been just a homeowner in an association, really since 1996. So I have a lot of perspective on all the different roles of operating an association. Today, we're going to be talking about a very hot topic in our industry, and that is how to handle disruptive personalities. Whether it's a challenging homeowner or a contentious fellow board member, we're going to talk about what are some approaches to diffuse conflict, handle harassment, and moving forward, what you need to do if your board is stuck or in a dysfunctional state and can't get out of it. We're also going to walk through what to do if a recall petition surfaces, meaning like a homeowner group puts together a recall petition for one or more of the board members, and including what legal steps the board needs to take if you receive a recall petition, what kind of key communication things you need to be doing with your owners, if you're hearing that a recall petition may be circulating in your neighborhood. And we'll also talk a little bit about how to restore productive leadership after a recall if it is successful. So whether your association is just facing drama or wants to be prepared, this class is going to give you practical advice and solutions for building a better, healthier, and more effective board. Although many of our participating cities, neighborhood, and community engagement offices offer valuable information and resources, including neighborhood grants to assist voluntary neighborhood associations and HOAs and condominiums with beautification and various community building endeavors. So we want to make you aware of that you should really try to reach out to your city's neighborhood services or community engagement team in 2026 to learn about what their offerings are. Some of them are offering individual HOA and condo classes. Almost all of them are offering grants through the city, town, or municipality that you're in for beautification projects, for improving lighting in your association, for installing new monument signs. And the reset on that is July 1st. So all that new money is going to be funded as of July 1st. So I really encourage you to engage with your community and neighborhood services offices in the respective city where your association is located, because they offer a lot of great resources for board members and homeowners and associations. So please be sure to check out the neighborhood services websites for each of the association, for each of the cities that are represented here today, and then also the cities that you may live in. Okay, so before we get started, let's do a quick little poll to see who's here today. So first question is, which city do you reside in, or which city is your HOA or condo located in? And let us know your current role with the association. So we opened up that poll, and we would encourage you please to participate so that we can have the best class for you here today. Okay, a couple things that I want to start, just some housekeeping things. Before we get started, today is St. Patrick's Day, which is one of my most favorite days of the year. With a last name of Mulcahy, you can imagine that I have a lot of connections to Ireland. My great-grandmother, Mamie Chambers, came to the United States from Ireland when she was 19 years old. And she, moved to Chicago and worked for Palmer House Hotel. And she was very instrumental in, all the grandchildren's lives. And also my grandmother was too. We have a lot of connections with Ireland. We're from County Mayo originally. I was able to visit Ireland when I was 24 and traveled around the entire country, which was an amazing experience. Some kind of little fun tips on St. Patrick's Day. It's my favorite day of the year. I kind of have a co-favorite day of the year. I love the 4th of July too. And I'm wearing a special pin that a very special person gave to me that represents St. Patrick's Day. I also have a picture of my wedding dress, which I'm going to show real quick here if you can see it. My wedding dress had shamrocks all over it to celebrate our Irish heritage. And so a lot of connections with Ireland for my family, and love this day to celebrate today. So probably we'll be having a green beer sometime in the afternoon today to celebrate. Okay, let's talk a little bit. So happy St. Patrick's Day to everybody. I hope you're having a wonderful day. Let's talk very quickly about the pending legislation in the Arizona legislature. Wow, this is going to be a big year for bills. We've seen over 30 bills that have been introduced in the Arizona legislature since January 16th, I think. And we are monitoring all the bills. As of right now, there are a number of bills that have passed either the House or the Senate. And we're going to be sharing a link to you in this presentation and also on Facebook Live of our summary of the bills to date and where they are in the legislative process. The only ones that we're making notations on are if they're moving. So if they've passed either the House or the Senate, those are the ones that we're really keeping an eye on at this point. And there are quite a few bills that are in that category right now. Starting probably in like April to early May, we'll start actually dissecting the bills that we think have a chance of passing this year or that have already passed at that time, so that you are well aware of whether you may need to object as a board or as a homeowner, or, just be aware of it, that the new laws that are going to be going into effect sometime this fall. So we'll keep you posted. Don't forget that our website for our firm always has an updated summary of the bills in the Arizona legislature that are pending. And we are updating that about once every week. So you can just go to our homepage of our website at mulcahylawfirm.com to get a quick summary of these pending bills. Now, remember, these bills have not passed. These have just been introduced into the legislature and are moving through the legislative process right now. As of right now, there are no bills that have been passed and by both houses and signed by our governor. So as soon as that starts to happen, you can be sure that we're going to be talking about those bills in these classes. Okay, today we're going to be talking about one of my favorite topics pertaining to associations, and that is dealing with difficult people and harassment. I think probably pretty soon the poll results are going to be coming up. Maybe there was a little glitch on the poll results, don't know, but maybe we'll put those in when we hit a breaking point in the presentation. Okay, so how do we deal? Oh, here we go. My office, I ask and they answer. Okay, so we have a really great turnout today from a number of different cities. So it looks like we've got 2% from Avondale, 6% from Chandler, 2% from Glendale, 4% from Goodyear. Let's see, 34% from Mesa. Wow, that's a really good turnout. Great job. 5% from Peoria, 11% from Phoenix, 21% from Scottsdale. Wow, that's amazing. 9% from Surprise, and 5% from Tempe. So every single city in the Valley that is partnering with us for these classes has participants today, which is amazing. Okay, what are your current roles here? We have 65% board members, 4% managers, 27% homeowners, and 4% in the other category. So, wow, really great turnout here today. Looks like right now we have over 140 people that are joining us here on Facebook Live and on Zoom. So amazing turnout for St. Patrick's Day. Okay, let's get right into our main topic, dealing with difficult people and harassment. As I said, this is a very interesting topic actually for me because it's something that pretty much every association has to deal with. And I am, getting questions on this 2-3 times a week. So we thought this would be a really good hot topic to tackle in this class today and give you some good practical suggestions on what's the best way to manage, difficult people and harassment, and even transitioning over into dangerous people who may be, residing in your association or making threats against your board or other homeowners. We have a great cheat sheet on this topic too. If you want to do a deep dive, you can find it on our website at mulcahylawfirm.com. And we're also going to be sharing it with you here today on Zoom and Facebook Live. So let's just start out with, there's a lot of national news stories and local news stories that cover disgruntled owners who act out violence. So there's national stories usually when there's more catastrophic, event that occurs, kind of like what happened at an association on the west side of Phoenix, probably about 20 years ago, 15 to 20 years ago, Montana Lakes. There was a shooting of board members by a former owner. And so these type of things, they're very sad and unfortunate, and we want to do whatever we can to help prevent these situations from escalating. But on the other side of the spectrum on this, we also just deal with difficult personalities, right? People who are just difficult, or disgruntled owners who just don't like how the board is operating, or maybe you have some sort of a disagreement among board members, a difficult board member. And so we really see this issue as a very hot topic in our industry, and it often leads to burnout of board members. I know I currently serve on my board. I have for many years. Some years are happier than others when you're serving on the board, just like anything. And right now we have a really challenging situation with another board member on our association. And I will be the first person to tell you that it is taking a toll on the other board members, myself included. And so we really have to think about what's the best way to manage when you have difficult people and when it's maybe transitioning into harassment or maybe even a dangerous situation for your community. So let's get right in and talk about what are some practical strategies. So first things first, let's talk about conflicts at a board meeting. So name calling, interrupting, and personal attacks should be prohibited at all board meetings and committee meetings. And this can be seen in the form of a board member to board member conflict, or maybe, a homeowner to board member conflict, right? So let's talk a little bit about if you have a conflict between board members, what's the best way to handle it? So I think we can all agree that if there's a lot of fighting between one or more board members and the rest of the board, it can bring productivity to a halt. You can't get things done because you're just fighting about a bunch of stupid things like, the wording of a motion or the language that, should be included in the minutes. Maybe they are a nitpicker. So basically what I would recommend is if you have a situation where you have board member to board member conflict, this is really the time when you need to bring in a third party to help you try to resolve the conflict, because in my experience, it doesn't usually go away. Some of the things that are creative solutions here would be maybe your management company can intervene, or maybe you bring in a law firm like our firm to come in and do a boot camp for your board and get all the issues on the table, right? What are the problems that are causing dysfunction among your board members? And so one of the first things that we do if we come in and try to help a board solve some of their dysfunction problems is we will have personality tests done on everybody on the board. And basically it's just, like a $30 online test. And we have a great cheat sheet that kind of interprets the different personality types. And kind of the rationale to do that is so that board members better understand themselves and also better understand their teammates, the other board members that they're going to be working with for the term that, the next year. And sometimes what you find when you do that, and everybody kind of shares their results, and then we talk about, what are the different personality types on this board, and how we all can effectively work together to get things done. And so when we do a boot camp, that's truly one of the first things I'll do if I see a high level of dysfunction and they need to address the issues. Another thing that, we will do is we'll ask everybody to be candid and write down what they think the problems are that are on the board. And we'll go around the table and we will address each issue, whether it's somebody feels that one board member is making the meetings longer because they're constantly asking questions and rewording motions and, demanding changes to the minutes, and it gets annoying. And that can actually be a personality type thing because, there's 4 main personality types under the DISC testing, DISC. And, some personalities want to do things fast. Let's get it done. Getting it done is more important than getting it right. And then there's other types of personalities on the board that getting it right is more important than getting it done. And those type of personalities sometimes can conflict. And so we kind of bring in what are the issues, and then we kind of talk a little bit about what the personality types are and how we can all soften our approach based upon, what our limitations are due to our personality. And people are hardwired, like you can't change people. So you have to just learn to work together based upon the personality type. So that's a really effective tool. We talk about the problems that are facing the association. We also talk about how to handle a board meeting so that we can limit the conflict. Okay, it looks really bad to me as an association attorney coming to board meetings when I see board members having open warfare and conflict in a meeting. That just is really bad look for your entire community. And sometimes a homeowner maybe who just moved into the community is going to come to your meeting and they're going to be like, wow, that's crazy what I just saw. That is a level of dysfunction and disrespect that I have never seen anywhere else. You don't want to have that. Okay, so what are some practical steps that we can share with you to limit board member conflict? First, if there's a lot of conflict on your board, the president really needs to, be the ringleader here of this circus, right? And you need to come up with some ideas that are going to limit conflict. So let's say the conflict is that one board member is dominating all of the time during the meetings with a bunch of petty stuff that they're coming up with and questions. And I want this rewritten. This doesn't make sense. And, there's making your meeting so much longer. So the best way to manage that as the president who's running the meeting is to have some rules for the meetings. Like, okay, we're going to have a timed agenda. And the agenda is going to be, we're going to discuss last month's meeting minutes for 5 minutes. And if we can't get through it in 5 minutes, we're moving on to the president's report. And each board member is going to get 30 seconds to comment on the minutes, or a minute to comment on, the bids for the landscaping company that, we're thinking about hiring. And each board member is going to be given a chance to talk once before somebody would get a second chance. And, sometimes you really have to get kind of strict on this and say, okay, 1 minute, timed, we'll have a timer and it's going to be 1 minute per person that's serving on the board to comment on things. If you want to talk a second time, it's 30 seconds as, a rebuttal. And that really kind of gets everybody, dialed into what they want to say because they only have a minute to say it. Now, I'm not saying do this for every association. I'm saying this is a practical suggestion. If you've got meetings that are running 2-3 hours and one person is dominating the conversation, and this is a really effective tool, having a timed agenda, giving everybody on the board a certain amount of time to contribute on each agenda topic, and then moving on. It's just a way to kind of move the meeting forward, be fair, and, limit that really long dialogue that maybe some of your board members, one or more of your board members may be wanting to do. Also, think about educating new board members on board processes and outstanding issues. Sometimes the issue is that, hey, you've got a new board member and they're asking a lot of questions. Maybe this is an opportunity for the president to take the new board member out for coffee and say, okay, let's kind of talk through how, what the issues are that we have right now. And this is how we manage the budget. And this is how we, handle this. And this is a real difficult issue that we're going to be talking about in executive session. Here's some prior history on it. So coaching the new board members so that there isn't any conflict or that they don't feel like they, have to ask a lot of questions at the meeting just to get up to speed. So coaching to help that new board member succeed is another strategy, that we think is very helpful to boards. Okay, a couple other things. Let's switch over and talk about the difficult owner. So let's say that we have a difficult owner in your community. We call these, I haven't coined this term myself, but I know there's a CAI publication from the 1990s that talks about this, the gadfly, right? What's a gadfly? It's somebody who's really outspoken regarding their views, regarding the management of the association or how the board is performing or the landscaping or whatever. And they're an expert typically at criticizing, cajoling, and pinpointing your errors as the board or the management company or how the association's being run. They demand change, they interrupt meetings, they attack personal integrity of board members, and they allege conflicts of interest by the board members, conflicts of interest by the management company. What's the best way to deal with the gadfly if you have one of those in your community? So what we recommend is at the beginning of the meeting, announce how the procedures or how the meeting is going to be run. So have meeting rules. And those can be, published in a newsletter or on your website too, in advance of the meeting. But really think about and work with your legal counsel about what rules comply with the open meeting law and still allow you to get your business done. Typically, the type of rules that we see would be no raised voices, no personal attacks, time limitations on how long the owners can contribute at a meeting. And there really is only, the practical side of owners contributing at a meeting, and then there's the law. So the practical side of it is most associations allow owners to talk during the homeowner forum. Most associations have a homeowner forum at the beginning of the meeting. And a good tip, if you've got a gadfly that comes and tries to hijack the meeting and, take 30 minutes of your time before the meeting, even gets into the meeting agenda topics, a good way to handle that is have a meeting rule that says, all of the things that I've talked about, no yelling, no personal attacks, keep your comments constructive and professional. And then also say during the homeowner forum, each owner gets 1 minute or 30 seconds or 2 minutes, whatever works for your board based upon the number of owners that want to talk during the homeowner forum. And that's a really effective tool, having meeting procedures so that at the beginning of the meeting, you can outline, okay, this is the expected behavior. And if you don't behave, here are the expected consequences, meaning that we'll give you a warning. And if you violate any of these meeting rules, then after the warning, then you'll be asked to leave. If you refuse to leave, we may have to cancel the meeting, stop the meeting, or we may need to get police intervention if it's getting to be, a physical altercation, which hope isn't happening ever. And so the first thing to deal with the gadfly is have a plan going into the meeting, right? Have your meeting rules, announce them at the beginning of the meeting, announce what the consequences are, and then enforce them uniformly, right? So, even if the non-gadfly is, talking out of turn or raising their voice, you have to remind them and follow the exact same procedure for anyone who's in attendance at the meeting, including the board members. Establish control. No one should be allowed to interrupt board meetings. So who's this on? This is on the president for sure of the association. The president should be, in friendly control of the association's meetings. So, announce the procedures at the beginning of the meeting for how the meeting's going to be run. When somebody, violates those meeting rules, in a friendly way, say, this is, you're violating the rule and, this is your warning. What we don't want to have is the president, yelling back at the owner and them getting into a confrontation. That's not a good look for anybody. And also the president had then lost control of the meeting. So we need to have the president be even in their responses and firm. but not in a raised voice kind of way, just in a, I'm in control of this meeting and in a calm and professional manner. And that just goes along with responding to owners when they, maybe they come to the board meeting and they're talking during the homeowner forum and they are arguing about something, telling the board that you don't know what you're doing or you're doing this wrong. You don't have to respond to every single comment. You can say, thank you so much for being here today. We know how much you care about the association and we'll take your thoughts into consideration. You don't have to say, you're wrong. We're not stealing money. You don't have to get into all of those attacks. You can welcome them to make a records request and you can politely, guide them in that, and let them know that there is nothing improper going on and our books are open. You're welcome to make a records request just so that you can see for yourself. The key thing is don't respond with anger. Don't argue. Don't trade insults. Even though you're a volunteer on the board and you may be tired from being at work all day and now you're coming to the volunteer board meeting and you're, got people yelling at you, you have to keep it together and be professional. And the best way to do that is just be calm. Listen. Most important thing, listen to what they're saying and then just move on. Thank you so much for being here. Thank you for your comments. We'll take that into consideration. You don't have to answer every question that's presented to you by a homeowner, especially if they're a gadfly and they just come to the meetings for fun to harass the board. Another thing, think about, use parliamentary control. So know when, and the board president really is the one that needs to be in control of this, know when to table a motion, know when discussion is going nowhere, right? And we need to just say, okay, sounds like we're not going to be able to come to any resolution on this today. And so let's just table this to next month's meeting and let's think a little bit more about, maybe we need to do a little more research. Maybe we give the management company a project. Maybe everybody just needs to calm down and think it through. And so using parliamentary procedure, knowing when, okay, we're going to table this motion, and also know when to limit debate. And the great way to limit debate is to have that timed agenda for the meeting, so that it's already on the agenda and it says, okay, we're only going to talk about the hiring of the new landscaping company for 10 minutes. And once we get to, the 10th minute, we need to round up our comments. If we can't come to any agreement, then we need to move this to next month's meeting. Okay, how to respond in a difficult situation. So sometimes you get the gadfly who either corners a board member outside of a board meeting, which I have a strategy for how to handle that. You need to just tell the homeowner, thank you. You run into them at the grocery store or at Starbucks and they want to, bend your ear about something. What you can do is just say, I so appreciate your interest in the association. I can't talk about this right now. Please come to the board meeting or please send the manager an email with whatever you want to let the board know and then get out of there. Try not to ever have a one-on-one conversation with an owner because what sometimes can happen is they walk away from the conversation thinking something totally different happened than you did. And there's no third person to prove one way or the other what you two discussed. So when you get the difficult person at the board meeting and they're really upset about something, ask the difficult person to explain the exact issue, right? So what are you upset about? Listen, don't cut them off, okay? Give them the opportunity with a reasonable amount of time to state why they're upset. Listen, very, very important to listen to the homeowners, okay? Ask them, what exactly do you want? Maybe they just want an apology. Maybe they just want us to know that they think the flowers in the community look horrible. And so, if they come and they're upset about the landscaping, what is a practical solution that you would like us to think about? Ask them that question. Give them that question back and see what they come up with. If they really go after you at the meeting, take a second to compose yourself, right? And recognize that we'll need to be professional in your response, right? And, you can acknowledge, hey, it sounds like you're angry about the situation. And I'm very sorry that you feel that way. We're volunteers. We are also concerned that the landscaping isn't looking quite up to par right now, and we're doing everything we can. In fact, we're going to be doing a walkthrough with the landscaper tomorrow, and we're going to be addressing some of these issues that you've raised here today. And we really appreciate you caring about our community and coming to the meeting to express your concerns. And just keep it calm and rational and professional. If you have any alternatives, like let's say they're upset that the management company isn't returning their calls, what you can do is say, hey, we've got the manager right here today. Why don't you stay after the meeting and talk with the manager and try to work out whatever issue you have? Typically, they'll say, I don't want to stay for the meeting. Okay, that is like 99% of the time they'll say that. Then you can say, please email the manager right away what the concern is, and we're going to instruct the manager that they need to handle that first thing in the morning, respond to you first thing in the morning tomorrow. Resist the urge to fight with owners, and resist the urge to win the argument. Okay, you don't have to win every argument as a board member. Your job is to listen and make decisions that are in the best interests of the association. So listening and asking them what they think a solution is, and then taking that feedback, constructive feedback, and trying to make a good decision. That's what your role is as a board. A couple things about harassment. Sometimes we see things turn into harassment. I can give a great example from my board, back from the time when I was the president of my board, the longest year of my life, mind you, where we had an inter-board harassment situation going on. We had a very difficult board member in my association who had a need for information and a need for facts, and always felt that there was a conspiracy going on our board. And that person truly made my life kind of miserable as the president, because at the beginning of my term, what I tried to do was meet with her and listen to her and try to appease her. But what I recognized after a while was, okay, she would come up with something. She would make an allegation that, like the financials were wrong. And then I'd spend a lot of time explaining to her that the financials were not wrong. And then I'd actually prove it to her and show her on, the bank statement or the financial statement, and explain to her what it meant. And she would never say, oh, you're right. She would just say nothing. And then she would move on to the next thing she was upset about. And I had a series of about 50 of these things in 5 months with her. Plus, she sent me 350 emails that every one of them I needed to respond on, just because if I didn't, she was going to, file a lawsuit or whatever. Those kind of people can drive you nuts when you're serving on the board, right? And it is a number one cause for board member burnout. So whether it's a board member or whether it's a homeowner, you really have to know when this crosses the line to harassment and, what your legal remedies are if this person is harassing you. So Black's Law Dictionary defines harassment as words, gestures, or actions which tend to annoy, alarm, or abuse another person. And so we need to look at what Arizona law says about harassment. So under Arizona law, it's Arizona Revised Statutes, Section 12-1809. Harassment is a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously annoyed, alarmed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. So if you're in a situation where you have either another board member that's harassing you, or maybe it's a homeowner who's contacting you as a board member, here's what you need to do. Okay, the first step is tell the individual verbally to stop, right? So if it's coming to you at a board meeting and, they're verbally attacking you or whatever, harassing you, tell them to stop. If it's verbal, you do it in person. If it's emails, you can send an email back saying, please stop contacting me. Please, if you have concerns, please come to the board meeting. The second step, if the harassment does not stop, you're going to want to have the management company or maybe the association's attorney, if you need a little bit more, authority behind a letter, write a letter to the person that is harassing the association's board, or maybe it's a board member harassing each other, and it gets to be kind of difficult because when I'm asked to do something like that, I really feel uncomfortable because, I work for the board, right? And I want to have a good relationship with the board. So typically I'll ask to just have a phone call with the two board members that are fighting, or maybe talk about it at a boot camp. But if we have a homeowner who is harassing somebody, we're going to send a letter for sure. Typically our firm will send a letter, and we tell them to cease and desist, stop the harassment. We define the harassment under Arizona law, and we tell them, stop doing this. And we give them an avenue to air their grievances. So, I just reviewed a letter last night before I went to bed that we were sending to an owner who had a physical altercation with another owner in the community. And the police were called. This person was arrested. And we are sending a letter now to this owner saying, cease and desist from causing a nuisance on the common areas, and stay away from, the individuals, that you had the altercation with. And we're considering whether or not we want to fine that owner for the behavior. And the board's going to look at that issue at their next board meeting. So if the harassment doesn't stop after you tell them stop, then it gets escalated to the management company or the attorney to write the cease and desist letter. Okay, sometimes the cease and desist letter isn't enough. Sometimes you've got somebody who's the Gadfly who has mental illness. And in that case, now you've got to go the legal route. And the legal route is to go to justice court and get an injunction preventing harassment. And basically the standard to get an injunction preventing, harassment is that, there needs to be a threat of harm or actual harm against, the person. One person has to be doing this, the other person. So threat of harm, and it usually needs to be two threats, or actual physical harm. So what are some examples that I've seen? We once had, many years ago, we had a homeowner who tackled a board member who was cleaning screens in their garage. And they were upset about some architectural decision, and they were walking by the board member's house, and they just lost it and came in and tackled the board member. Okay, that was an easy one. The board member went to the justice court. They filled out the paperwork to have an injunction prohibiting harassment in place against the owner who tackled him. And the judge, how it works is you go into court, justice court in your precinct that, your association's located in. You fill out the paperwork. They have form paperwork you fill out. You explain what happened. You're going to need as much evidence as you can when you go in there. Hopefully you file the police report if there's been physical harm. And you just go in front of the judge and say, this is what happened. And the judge, in that case, agreed, hey, this person's behavior is harassment, and I'm going to issue an order saying this person must stay 50 feet away from you or 100 feet away from you at all times. Now that gets served on the owner who is the harasser, and that owner has a right to have a hearing if they want to have a hearing in justice court to determine if that injunction stays in place. So an injunction is just a piece of paper saying person A needs to stay away from person B. If person B violates that injunction after they've been served with it by a process server, they can go to jail. You can call the police if you can prove that that person, came into your house or knocked on your door or whatever. When those injunctions are in place, if it's a board member against a homeowner, that homeowner can't physically come to the board meeting. So you will need to make like an accommodation. If they want to come to the board meeting, have it appear by Zoom. Or have the meeting by Zoom to avoid any sort of verbal or in-person altercations. So injunctions, are not given out easily, right? So you're going to have to prove threats of harm. I would say 2 at a minimum, or actual physical harm for the court to give you that. Okay, so we kind of talked a little bit about, harassment and what are some suggestions, to best deal with harassment. I just want to spend just a very brief minute talking about a bully. Sometimes we run into a situation where we have just like a bully and in the community, and nobody likes to deal with a bully, right? We have a cheat sheet which gives you some practical suggestions on the best way to handle a bully. And, probably the best advice I can give you on dealing with a bully is escalate the contact or the communication to the management company or the attorney. And the best way, I think this is, kind of common sense knowledge to deal with the bully is to push back hard. So if the bully is, really bullying board members, or another owner, the association needs to push back hard and threaten legal remedies, consider injunctions prohibiting harassment. Just trying to appease the bully is never going to make that situation better. So we encourage you to take a look at our cheat sheet on it. I think we have some great tips on how to best deal with, bullying, whether it's owner bullying, maybe it could be a board member bullying. That's a very difficult situation as well. So I encourage you to check out that cheat sheet that we have on bullying. Okay, a couple other things that I want to talk about today would be recall process. So what does Arizona law say about board recalls? How do we handle it if we hear one brewing in the neighborhood? How do we handle it if we receive the petition? This is a very common topic that our firm is handling. I would say that we receive a couple of board recall petitions from associations that we represent every quarter. So I wouldn't say it's one a month, but I would say it's about 2 every quarter, that we see. And so let's talk a little bit about what does this mean? So there's a special Arizona law that allows owners to have a recall process of a board member, multiple board members, or the entire board. And it's set up under Arizona law, and it trumps whatever's in your bylaws. That's very important for you to know. Whatever it says in your bylaws, just it doesn't matter. What is controlling is state law. And there's an identical law in the Planned Communities Act and the Condominium Act that specifically tells us how to handle board recall petitions. So Planned Communities Act is on recalls is A.R.S. 33-1813. Condominium Act is 33-1243, and that's going to give you the exact language that you need on how to, how a board recall process works. So again, you want to, no matter what your bylaws say, you need to follow as a board, the state law on how the recall process is, set up and what your responsibilities are as a board if you receive one. Okay, let's talk a little bit about first, let's just do a little pre-recall discussion. Okay, so let's say that you as a board are hearing from owners that, hey, somebody stopped by my condo or somebody stopped by my house on Saturday and they wanted me to sign something to get rid of the board. They wanted me to sign something, to say that the board's doing a bad job. That right there is a very important and pivotal moment for your board. When you hear that that's happening, or maybe you hear a homeowner that says, I'm going to start a recall. I don't agree with how you handled my violation. I'm going to go start a recall process. So either one of those, you hear about it directly from the organizer, or maybe you're starting to hear that there's disgruntled neighbors talking about it, or maybe somebody's showing up on people's doorsteps asking them to sign a petition. As a board, that your antenna should be going way up. Okay. And why? Because there's a way to avert or to avoid a recall. And this is a very practical in the trenches tip that I'm going to give you. So if your board's hearing that, hey, this might be happening, your board needs to get in touch with your attorney and strategize. So I recommend that the board contacts me right at that point. Why? Because I can give you suggestions right then and there as to how to avoid having the recall. Recalls are extremely expensive for associations. They usually result in somewhere between $5,000 in legal fees being incurred. We have seen some recalls be as high as $80,000 in recall attorney's fees. Now, obviously, the $80,000 one is when there's litigation after the fact, and the recall is a nightmare. Most are in the $5,000 to $10,000 range. So a lot of you don't budget for that, right? So you don't want to have a recall. You don't want all the unrest that a recall creates. So what's the unrest that a recall creates? Well, the realtors find out about it and they start saying, well, the HOA has a lot of problems. There's a recall going on right now on the board. So if you're trying to sell your house, buyers are hearing this and they may say, you know what, I don't need some psycho HOA. I'm not buying this house. And so it can affect property values. It can affect your ability to sell your property. And it can be very expensive. So what are some tips? Board hears little, rumors or whatever that there's a recall petition going. They contact my firm. What do I tell them? I say, we need to get it in high gear and start communicating with the owners. If you're hearing this, people are unhappy about something. We need to get ahead of this. So what I typically will recommend is that the board increase their communication to the owners so that owners know what's going on. So that when someone knocks on their door and says, hey, the board is thinking about doing an increase in assessments that's 50% higher than last year. Okay. The communication that we're pumping out to the homeowners is going to contradict that. So that whatever, story the group is trying to get you to sign the recall petition with, there's good communication, constant, effective communication going to everybody saying, hey, that's not true. This is what we're doing. Sending out minutes, sending out a newsletter, inviting people to come to the board meetings. These are all really good suggestions. Another really good suggestion is have a town hall meeting. Hit it right on the head. Say, we understand that there are some people in the community that are unhappy with how things are going right now. And we want to have a town hall meeting to talk about it, air grievances, to talk about solutions, and to work together. Because recalls are very expensive. You can tell them the dollar amounts, how much it's going to cost, and they can decrease our property values and make it harder for you to sell your property. So let's all come together at a town hall and talk about the issues. Now, I've done a number of these town halls over the years, and what usually happens is you've got a handful of people who are the leaders of the recall. Sometimes they don't come, right? Because they don't want to get along. They don't want to air grievances and work for solutions. They just want to fight. But a lot of people, these are usually higher participation meetings, and a lot of people come just to listen. And so you as a board, you want to listen. You can't be, in charge of, only telling your side of the story at these meetings. You need to listen. So it's open mic night, right? You got to let them talk and listen and be nice as a board and say, we understand you're upset and we're going to do better. There's usually some level of acknowledgement of a problem and acknowledgement that we need to do better. That is a very effective solution on how to counter a recall before you even get the petition. And I would say probably 98% of the time, when you do that, there is no recall petition that is ever submitted. So that's a really good tip that's going to save your association a bunch of money. Okay, let's say that you just get a recall petition out of the blue. Let's talk about what the law is on recall petitions. So there's a very specific procedure under Arizona law that has to be followed. So it depends on how large your association is. So if you have 1,000 or fewer members, if a recall petition is submitted to the board, it must be signed by persons who are eligible to cast at least 25% of the votes in the association or 100 votes in the association, whichever is less. Okay. If you have more than 1,000 members, the petition has to be signed by persons eligible to cast at least 10% of the votes in the association or 1,000 votes, whichever is less. So most of our associations that we work with are 1,000 or fewer members. So it's probably going to be that 25% of the votes or 100 votes in the association that would need to sign that petition in order for the petition to move forward. So the board receives the petition. First call you should make. First two calls you should make. One to your manager, one to your attorney. Okay, we need to have a powwow pronto to discuss how we're going to handle the recall. So the petition gets submitted. Really, the first thing that we do is we check to see if they got the percentage that they needed. And the best way to do that is to look at all the names on the petition. And typically our law firm does this. And we cross-check to see, did a record owner sign the petition? If a renter or somebody who is not a record owner signed the petition, that name gets crossed off. Okay, they are not a valid owner. They can't, sign the petition. So we, X out that name. And that happens a lot, mind you. That really does happen a lot. There's always a handful of names that are on there that, are not record owners and can't count them. Also, we cross-check to see the delinquency list with who filled out or who signed the petition. If they're delinquent, we also cross off their name because they're not allowed to sign it because they have to be eligible to cast, the signature on the petition. So if they're delinquent, their name gets moved off. Okay, after you do this step, if they still have the requisite percentage or number that they need, the petition moves forward to the next step. If they don't have the number that they need, the association needs to write back to the persons that are, on the petition or the ringleader, and then also send something to the entire community. So we received a petition. This is how we handled it. We gave it to our attorney. The attorney, validated the names and the delinquency list, in comparison to the petition, and the petition failed because they didn't have the requisite percentage under Arizona law. And doing that in a timely manner is really important, okay? Having your attorney involved is really important because you want to make sure that if it fails, you want to have the legal justification that it failed. Because if you make a mistake on that, there's some pretty serious consequences that we're going to talk about in a minute. Like if, let's say you made a mistake and you said, hey, they didn't have the requisite votes, but they actually did. And you don't take action to move that petition forward and have a meeting of the membership to vote on the removal. A consequence could be that 30 days after the petition was submitted, if it was a valid one and you didn't act on it, the entire board gets removed. So like real serious consequences. Okay, so let's say that you, get through the first step of verifying the signatures on the recall petition. What's the next step? So the next step that we do, and we got to do that quickly. So that needs to be done like within the 3 days after receiving the petition. Why? Because if it moves forward, we have to have a recall meeting of the membership within 30 days after the recall petition is submitted. So that's like a real fast turnaround. That means we have to have a meeting of the membership with notice of the meeting and ballots and gotta find a location. All of that needs to be mailed to the owners by U.S. mail or hand delivered in person to the owners. Most associations have to mail it if they're, large and they can't hand deliver it to everybody. All that needs to take place in 30 days. So that's a real fast turnaround. So when we get that removal petition, we got to act on it right away. Okay, so we have to have a special meeting of the membership, and that's 30 days, within 30 days after the receipt of the valid removal petition. We also have notice requirements under the law. So we have to give notice of the special meeting to recall the board members or all the board at least 10 days in advance of their removal meeting date. And we also have to give them their ballots at least 7 days in advance of the actual removal meeting date. So there are lots of deadlines here that we need to map out with the attorney. I would recommend that you just have the attorney write the letter to the owners and the ballot to help move this process along. Oftentimes, the board members that are being recalled ask to put a letter in when the notice of the meeting and the ballot is sent so that they can have a chance to put a rebuttal as to why they shouldn't be removed or their position on this. And sometimes we even have a town hall at this point, this juncture. If we didn't have one before, maybe to air grievances, just to try to get people to vote against it if the board wants to stay in place. Okay, so we got to have that special meeting in 30 days. We got to have a notice and a ballot, and there's special timelines for all of these different things. Let's talk about the actual meeting. We get to the meeting date, and there's a special quorum under Arizona law to conduct this recall meeting. It trumps whatever's in your documents. So it's 20% of the membership is the quorum for the recall meeting. Okay, we get into the recall meeting. You probably have 80% of your ballots are returned by absentee or mail-in ballot. Maybe you have 10% of the people that show up in person. At the meeting, you count the ballots, and you want to make sure you have a quorum at the meeting. Otherwise, the meeting can't move forward. So 20% quorum. What we find is that you always have a quorum for these type of meetings. These recall meetings, these are the most highly attended meetings in your association. Why? Because there's a lot of drama associated with it. I always say it's the social event of the year for your association, a recall meeting. People come because there's drama. People show up on Zoom because there's drama. Okay, so what's the percentage that's needed to remove a director or directors from office? You are going to need a majority vote of all participating eligible voting members. So of the ballots that are returned, you're going to need to verify that, okay, a record owner signed the ballot, and you're going to need to count how many ballots you got back. It's got to be a quorum. You need to determine the majority of the ballots. Do they vote in favor to remove the director? Yes or no? And in my experience, most of the time, there's not a recall unless the board is not handling things properly, or the board doesn't listen, or they're rude. 90% of the time, maybe even a little higher, 95% of the time, the recall doesn't go through and the board members stay in office. Why? Because people really don't want to be on the board, right? Because being on the board is a very difficult and time-consuming job. They just want you to hear they're unhappy. We don't like how things are being run. We want to change direction. Okay. And so if you're communicating as a board and listening and acknowledging, that you can do better and that we're going to take this feedback and go back to the drawing board or whatever, it's going to save your position on the board. Now, sometimes the board will receive a recall petition and they'll say, I quit. I don't need this. And that's okay. Actually have a recall right now that we're working on, and one board member being recalled, and that board member is deciding right now, I think I'm just going to quit, right? And if that happens, have them resign in writing, and then you send a letter to the membership saying they received the board recall petition. This board member decided to, withdraw or resign from the board in writing, and therefore it's not necessary for us to move forward with the recall petition. And we've saved a lot of money, frankly, by doing that. But 99% of the time, board members do not want to resign, and they want to stay in control of the association because they know that this other group may not do as good of a job, and so they're going to stick it out and go through the recall. Okay, a couple things to remember on the recall. You have to keep all of the documents from the recall for at least 1 year. So the ballots, the notice, the recall petition, any written document that's related to the recall, you got to keep for at least 1 year under Arizona law. There's only one removal attempt per term. So if we receive a petition for, 3 of the board members to be recalled and it fails for whatever reason, those 3 board members cannot be recalled again during this same term that they have serving on the board. How do you fill vacancies if you do have a board removal? We got to look at the association's documents, okay? If there's at least one, but fewer than a majority of the board members, the vacancies shall be filled as provided in the association's governing documents. Typically, the remaining board members are going to appoint the replacement. If there's been a removal of a majority of the board, or if the association's governing documents do not provide a method for filling board vacancies, then the association has to hold a special election for the replacement of the removed directors at a separate members meeting that is held no longer than 30 days after the meeting at which the board members were removed. So again, really important to keep your legal counsel for the association, in the loop and talking with them to help you through this process, because it is really very complicated and you want to make sure you do it right. Remember that if you have a board member that's removed, pursuant to Arizona law, that they cannot serve on the board again until the expiration of their original term of office that they were removed from, unless the governing documents provide for a longer period of ineligibility after a recall. Let's see if there's anything else that I can think of on the recall. I think really those are the main points on the recall that I think will be helpful for you and your association if you're facing this particular issue. Okay, so it's exactly 12 o'clock. Remember, if you need any help navigating the recall process, please feel free to reach out to our firm. We are here to help you. and answer any questions that you may have. Okay, some concluding remarks. We had over 148 viewers at peak on Zoom and several more on Facebook Live. So over 150 people joining us here today for this class. Amazing turnout. Thank you so much for being here today. Let's talk about our upcoming opportunities to learn for board members, managers, and owners in April. So we have our first Fridays in April on Friday, April 3rd, and that's where you can ask any question at no charge. And we hop on Zoom at 9 a.m. and answer all the questions. You can find out how to do that by going to our website at mulcahylawfirm.com, sign up and ask your question, and we answer them live starting at 9 o'clock on April 3rd. We also have our fourth class for the virtual HOA Academy that I'm teaching in conjunction with numerous cities and towns in the Valley. And that is going to be Tuesday, April 21st, 2026 at 11 a.m. on Zoom and Facebook Live. And we're going to be talking about kind of a scary topic. We're going to talk about ethics, accountability, fraud prevention for HOAs and condo boards. So we're going to talk about, the financial side, what to be careful for, to make sure that we're not having fraud in your community. We're going to talk about ethics of serving on a board. What is a conflict of interest? What do you do if there is one? How do you avoid them? These are all really great topics for us for our class in April. So I hope that you will be able to join us for that class. Just concluding remarks for today. Happy St. Patrick's Day. I hope you have a wonderful day today. And we look forward to seeing you at our 2 free virtual educational opportunities in April 2026. Take care, everybody. Have a great day.